Welcome to today's program titled The Future of Arbitration, Paradise Lost, the Risk of Mass Arbitration. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recordings and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Noah Finkel. Noah, please go ahead.
Morning and good afternoon, everyone. I'm Noah Finkel. I am a partner in Seyfarth Shaw's Chicago office, and I am one of the co-chairs of our National Wage Hour Litigation Practice Group. In litigating wage hour cases and in helping clients comply with wage hour laws, one thing about my practice that I've done is help clients avoid wage hour class and collective actions through, among other things, arbitration agreements. And I've done that, including with Epic Systems in its case that went up to the Supreme Court, and as many of you know, was one of the cases that paved the way for employers to use arbitration agreements as a way to resolve wage hour and other disputes on an individual basis. I'm joined today with two of my partners from Boston, both of whom are key players in our wage hour litigation practice group, Patrick Bannon and Barry Miller. Like me, they both spend most of their time litigating wage hour disputes and advising clients on how to avoid them. And in particular, Barry and Patrick have both spent a good amount of time in helping clients navigate what we call the mass arbitration phenomenon. And we're going to talk about that in a little bit. This, of course, is the second of 3 webinars we've hosted on the future of arbitration. A few weeks ago, we hosted one on the new act of Congress recently signed into law, the Ending Forced Arbitration and Sexual Harassment Act. We have a third webinar scheduled for April 26th on the unique California aspects of arbitration agreements. And today, we're going to be talking about mass arbitration. If we can go to the next slide, please, Kate. This is what we're going to be covering today. We're going to be talking, I'm going to be setting up kind of what the mass arbitration phenomenon is through a couple of these. And then Patrick is going to talk about what kind of response employers have met to the mass arbitration phenomenon from arbitration providers and how employers can avoid becoming targets of a mass arbitration campaign. And Barry is going to address how employers who are facing one can best respond to it. So if we go over the next slide, let's talk first about kind of what this is. So many companies have reached arbitration agreements with their employees. The scopes of these vary. Some cover all employment claims, some cover wage hour only, and some do some kind of mix. All of them, though, for the most part, either implicitly or more frequently now, explicitly require that arbitration be done on an individual basis only, so that there can't be a class action or can't be a collective action under it. As you know, those are incredibly expensive to defend. They are procedurally difficult for a lot of companies, and they result in extremely high fees, much of which go to the lawyers involved, not necessarily even the employees. Typically, in arbitration, the arbitrations are administered by a third party. The two most prevalent are the American Arbitration Association, or the AAA, and JAMS. And under their rules, what happens is there's typically, in the case of the AAA, a $300 fee for a claimant to pay, which sometimes employers promise to pay, and then fees that total roughly, well, there's two types of fees that the AAA has. They total $2,650, and those are basically the cost of a ticket just to play. After that, there are arbitration costs that the employer always covers, and as well as legal fees, of course, that each side covers on their own, subject to any fee-shifting provision under the substantive law. What happens here, the upshot of this, is that there's typically no class or collective action for an employer to defend, and from the employee's perspective, they don't get slowed down by the class and collective procedures, and they actually get to the merits of their dispute with an employer on a relatively quickly basis before a neutral arbitrator. So it's somewhat of a win-win for employers and employees, perhaps not so much for the lawyers involved. But this system has been used by many companies, on an increasing basis over the last 20 years, and particularly after the 2018 decision in Epic Systems. But that's where the mass arbitration phenomenon enters. So Kate, could you please go to the next slide? What we've seen lately is a growing segment of the plaintiff bar that is using arbitration agreements and arbitration programs against employers, particularly large ones. And what they're doing is running social media campaigns. You can see one on the, a typical one on what a slide would look like on some, or on the right side of the slide, what one would look like from the viewer's perspective on their phone, where it's incredibly easy for someone to sign up. All they fill out is this online form, and the plaintiff's attorney is able to collect literally thousands of these through an effective online and social media campaign. And I talked earlier about how there's always, in the case of the AAA, a $2,650 fee to pay at the beginning of a case. If the plaintiff's counsel is able to show that they have 1,000 people signed up, the employer is then facing a bill to pay immediately of $2,650,000. I'm sorry, $2,650,000. That again is just the cost of that's the price of a ticket just to get into the stadium, and doesn't involve anything after that, including arbitrator fees and of course their own attorney's fees. And the plaintiff's counsel is able to make a very effective appeal to say to the employer, would you like to pay these fees and litigate this dispute and incur additional costs, or would you like to pay me some other fee before I file these? And you can see why it might be preferable for an employer to just pay that fee to the plaintiff's counsel right up front through an early mediation. We can go to the next slide. You can just see here what some of the what some of the online ads look like. They make it extremely easy for someone just on their phone to sign up for this case, and that's one reason why plaintiffs' counsel are often able to get, if not hundreds, thousands of clients to sign up and assert the claim, really regardless of the merits. You can see there's not much of an inquiry into that. The real threat here is the initial fee that the employer would have to pay to the arbitration provider. So what I'd like to do now is turn it over to my partner, Patrick Bannon, to discuss what one can do to avoid or at least minimize the chances of becoming a target of one of these mass arbitration campaigns.
Thank you, Noah, for painting that somewhat grim picture of the problem that employers are facing. And before I turn to some possible solutions, I'm going to make it a little bit grimmer. Some of the other key players in the arbitration space are AAA and JAMS and state governments and state AGs. And they're all aware of the mass arbitration phenomenon, and they've responded each in their own way. Some employers have gone to AAA and JAMS after having mass arbitration and said, you can't arbitrate all these. We shouldn't have to pay all those fees. I think it's fair to say that AAA and JAMS do not see it as their job to rescue employers from the problem of mass arbitration, and they see themselves as neutrals, and so they've taken the position that the filing fees have to be paid as written in the rules. And if that turns into a $2.6 million upfront bill, then that's what it turns into. And AAA has a new fee schedule for mass arbitration specifically, but it's not significantly, it doesn't solve the problem for employers. So AAA and JAMS don't see themselves as in the role of rescuing employers. State attorneys general and the state of California, I think maybe being a little bit unfair to them with a little poetic license, they see it as their job to make mass arbitration as problematic as possible. I think they don't generally love arbitration of employment disputes, and they see great irony and poetic justice in employers ending up with more arbitration, basically drowning on arbitration. So 12 state attorney generals, for example, in November of 2019, wrote letters to the AAA and JAMS, essentially saying that we're investigating whether employees are facing barriers to arbitration, and we want to make sure that employers are paying all the fees when they're due. It's a matter of concern to us, and please provide us with a lot of information. So just in case AAA and JAMS were tempted to be anything but right down the middle on this issue, they have 12 state attorney generals watching them to make sure that they don't do anything that could be seen as favoring employers. And then the state of California, as many people on the call undoubtedly know, passed a law colloquially called SB 707 that says that the party that drafted an arbitration agreement, if the agreement provides for fees to be paid to the arbitration sponsoring organization before the arbitration can start, then the drafting party must pay those fees promptly within 30 days unless otherwise specified in the agreement. And if the employer doesn't, it's the employer who's the drafting party, so I'll just say employer. If the employer doesn't pay those fees, the penalties are draconian. It could mean forfeiting the case, just losing by default. And it could mean being barred from arbitrating any other cases. It's designed to make it as painful as possible. So that kind of frames the problem for you. Plaintiffs' lawyers are trying to find ways to hit employers with thousands of these claims so that there's no way to cost effectively figure out whether there's any merit to them, leaving the employer no choice but to roll over and pay ransom to the plaintiffs' lawyers. The next slide, please, Kate. I'll now try to turn to a little bit more constructive look at this. What can employers do about it? And so there are a few possibilities that employers can consider. Obviously, they could consider rescinding arbitration agreements. That's the safest. If you really want to be sure you never get hit with mass arbitration, you can just rescind your arbitration agreement. Or if you're thinking about rolling one out, think again, or at least factor in mass arbitration. Not to say that's the right move, because arbitration agreements are there for a reason. They can avoid class and collective actions in court. But if mass arbitration is an intolerable risk, then one way to avoid it is just to jettison arbitration, and that will undoubtedly make the plaintiffs' bar thrilled, because they've been trying to prevent arbitration for many years now. And then one more idea that's not on the slide, because it's not something that's easily implementable, but is a serious point. One way to become a less likely target is to have terrific employee engagement. To some extent, in the traditional labor context, if a company is in danger of being organized by a union, there's a constant sort of ad campaign going on for the hearts and minds of the employees. We might be moving towards a world where all employers face that, where if they have employees who are disengaged and angry, they're going to have online opportunities to file claims against the employer anytime they pick up their phone. And so employee engagement, I think, is is something to do that can reduce your risk of becoming a target. But so let's assume you're an employer that has arbitration or wants arbitration and likes it and wants to keep it, and you're doing what you can to keep your employees engaged. What else can you do, next slide please, to make yourself a less likely target for mass arbitration? Here's where I'm not big on doing all kinds of warnings and caveats, but I really have to give them in this case. We're going to propose some ideas for how you could amend or you amend your arbitration agreement. And we don't know whether they're good ideas or not for sure, because these provisions that we're suggesting generally have not been litigated. They certainly haven't been litigated in every state. So they might be unenforceable, and worse, they might take down your entire arbitration agreement. So I took a whole slide to say, be careful. It's not one size fits all. This is the skunk labs, if you will. These are experimental ideas. Next slide, please. And here's the substance of my contribution to today's webinar on one slide. Here are our 8 ideas, and others may have others, but these are the 8 most promising ways that we've thought of to try to make your arbitration agreement less hospitable to the plaintiff's lawyer who wants a mass arbitration campaign. And I'll just go through them quickly, and if people have questions, type them into the question field at any time. I'm so tech savvy, I'll probably be answering the questions while I'm talking to you. No, I won't really, but we'll answer them at the end, or one of the panelists who's not speaking can try to answer. So option 1 for revising your arbitration agreement, which I think, depending on the day, is my personal favorite, is to provide in the arbitration agreement that before an arbitration demand can be filed, the employee must participate in some form of conciliation. Again, in the traditional labor context, it's very common to have a grievance arbitration process. They almost go hand in hand more often than not. And before you get to go to the arbitration under your collective bargaining agreement, you have to go through a grievance process. First, talk to your supervisor, then have a sit-down meeting with the supervisor's supervisor, and see whether you can work it out by talking about it. There's no reason in principle that couldn't be applied in the non-labor context, where if someone has a claim, they think they've been treated wrongly by the company or they're owed pay by the company, they would be required to sit down with someone in talent, HR, or someone in their chain of command and explain what the problem is and give the company an opportunity to respond. And the key is that be required pre-arbitration demand, and that the employee agree in the arbitration agreement that they can't file an arbitration demand before doing that. Because that would then allow the company to say that this isn't a valid demand because they didn't comply with this process, and we don't owe arbitration fees, and then the plaintiff's lawyer doesn't have the leverage that forces the company to engage in the big settlement. So that's one idea. Two is to require in the arbitration agreement that a valid arbitration demand have some actual facts behind it. In the really big campaigns, where plaintiffs' lawyers have filed thousands and sometimes tens of thousands of demands, they tend to be word processed cookie cutter demands, where all that's different is the employee's name and address, and maybe 1 or 2 other slight variations, but they tend to be cookie cutter. If the arbitration agreement requires that a demand state what's the basis of the claim, you're not going to want to require a whole lot of detail, because courts aren't going to want you to put up barriers. But to ask for some reasonable explanation of what the issue is in the demand, it will help advance resolution of the dispute on the merits, which I think really is the goal for most employers. But B, it will make it so that a plaintiff's lawyer can't just use a word processor and a clerk to file 1,000 arbitration demands with a keystroke. So it makes you less vulnerable. So those are sort of what you can do to try to make it harder for a demand to be filed without anyone really knowing what it's about. Kind of bogus cookie cutter demands just to trigger filing fees. You'll want to. Well, I'll talk about making sure that works for your arbitration provider in a minute. The third option for changing your arbitration agreement is to require special procedures for mass arbitration. Some employers and some arbitration providers have begun using what's sometimes called a bellwether approach, where if you get a certain number of arbitration demands in at the same time that are related and all against the same employer, it's deemed a mass arbitration portfolio. And then that arbitration portfolio, per the terms of the agreement, is treated as a bellwether, as like a mass tort, where you take a few of the cases, you call them bellwethers, you resolve them as quickly as you reasonably can, and then you let the parties have a chance to settle the mass of the cases based on the outcome of the bellwether cases. The key for that approach to work is to make sure that the filing fees for the thousands of arbitration demands that are not bellwethers don't immediately become due. So you provide that if 1,000 cases get filed, 997 of them get stayed, for example, 3 of them get tried on as an expedited basis as you can. The filing fees aren't due for 1,000 of them. They're just due for the ones that go forward or for some other small subset. And then after you know who's going to win or lose on the merits, you have a mediation and see whether you can resolve the entirety of the mass arbitration portfolio. So that may be an improvement on the status quo. It may not be a perfect solution, because if there is no settlement of the mass arbitration portfolio, then it's still there and something must be done with it, either in arbitration or in court. But I think it's still an improvement over the sort of checkmate that can happen where you just get a bill for 1,000 demands and you have no good alternatives. I'll fly through the rest of these because the rest of them I think are a little bit simpler and easier to understand. But number 4, though, is very important. You need to make sure that if you do something innovative with your arbitration agreement, you have to make sure that your arbitration provider is going to be willing to administer it. So if you require pre-demand conciliation and the arbitration provider says, oh, we don't recognize any of that, we have a demand here and it's a demand, so you owe the fees, then you haven't gained very much. It's probably still better than nothing, but you haven't gained very much. So there are alternative arbitration providers out there. You know, we work with and love all the arbitration providers in the universe. From AAA is probably the oldest, but there are new ones who are coming along who are trying new things and open to experimentation. And so you know, someone who's trying to figure out how to solve this problem should probably think carefully about all the options. Another option is to provide in the arbitration agreement that if a mass arbitration portfolio comes along, the employer would say something like, we don't have the resources to arbitrate more than X cases. So if more than X cases come along at any given time, then we have the option to waive arbitration and pull ourselves out of arbitration. Then, of course, you're back in court, but that may be better than being in the $2.6 million checkmate arbitration land. Number 6, you can make the claimant pay an increased share of the arbitration cost. Obvious trade-off in terms of making it more likely that your agreement will be not enforceable. So it may not work in some places. 7, you could carve out the types of claims that are most likely to be mass arbitration claims. You could say that wage hour claims, for example, aren't going to be subject to arbitration, and leave discrimination and harassment claims, which are less likely to be cookie cutter. But of course, if you do that, then the wage claims are most likely to be class and collective actions. So there's a trade-off there. And then finally, before I turn it over to Barry, while he still has enough time for his materials, you can carve out small claims. You could provide in the arbitration agreement that if the amount being sought in a particular claim, and I should add, you could require that the person specify or estimate how much they're seeking, and you could provide that if the amount is too small, either you could say there's special procedures in arbitration to make it cheaper to arbitrate, or you could just say, you know, that whole claim is not going to be in arbitration after all. It's going to go into a small claims court. Again, as with all of these, no guarantee that a judge would enforce that, but it could work. It really is painful to have a mass arbitration campaign where the general counsel gets a letter that says, guess what? You're going to face fees in 30 days for $4 million. And some of the claims that are triggering that huge exposure could be for like, 3 hours pay for someone who worked for a couple of months. So it literally could be a $500 claim triggering or contributing to a $6 million leverage on the side of the plaintiff's lawyers. So we don't have a silver bullet, but we have 8 bullets, one of which may turn out to be a silver bullet, and we'll all have to tackle the problem and find out the answers to that together. So with that, I will turn it over to Barry to tackle the even more difficult problem of what to do if you fail in your efforts not to become a target. Barry?
Thanks, Patrick. In a program that includes a lot of bad news, this might be the worst part. That's why I wore a tie, to lessen the impact on the audience here. And we've kind of divided the world into folks that may be trying to avoid a mass arbitration campaign and folks that are responding to one. So we've included a pause here to discuss the types of companies that are most susceptible to these sorts of mass arbitration campaigns, because it's really not an even playing field in that regard. One thing that is really critical about these mass arbitration campaigns is the use of social media. We haven't talked about the how of plaintiffs' lawyers mining data to go out and chase these plaintiffs. You've seen a couple of the ads that pop up into people's streams, but we've seen under the tent a little bit in defending some of these mass arbitration portfolios, the lengths to which plaintiffs' lawyers go, which oftentimes include writing checks to social media companies like Facebook and LinkedIn, so that the advertisement that you saw when Noah was talking would get inserted into the feed of a given person if, for example, their Facebook page lists them as working at a given company. So plaintiffs are paying for access, which is one thing that makes this mass arbitration phenomenon new. It would have been very difficult or impossible for plaintiffs' lawyers to engage in this sort of self-help without recourse to social media. And that has spillover into the list of companies that are most exposed. So one thing that is going to increase your exposure profile is if a lot of your employees have social media and use it for work-related purposes. A lot of your folks are on LinkedIn. It's just very easy for plaintiffs' lawyers to get them. We also see the plaintiffs' lawyers targeting certain types of jobs because of the claims that they can assert. In these mass arbitration campaigns, we don't see a lot of plaintiffs' lawyers contending, for example, that a given position was misclassified as exempt from the administrative exemption. We see a lot of independent contractor claims in the gig economy context. And for folks who are classified as employees, what we see often are off-the-clock claims, so that you don't have any grand claim by the plaintiff's bar that this position is misclassified and these people should have been paid hourly all along. Instead, you're talking about a group of hourly employees who are claiming from time to time, I worked off the clock. I skipped a meal break. I punched in early. I punched out late. And one other thing that will increase a given company's exposure is if their employees' information is available to the world at large outside the context of social media. So I've seen this, for example, in the healthcare context, where many states have databases of people who maintain credentials as registered nurses. And it is kind of astounding, the information that an enterprising plaintiff's lawyer can pull out of those databases. And they send direct mail hard copy advertisements to people's homes based on those databases. And I've seen it in the mortgage lending industry as well, because there's a statute that requires anybody who essentially touches a mortgage to register with the nationwide mortgage licensing system. And you can go on the internet and pull up anybody there, including an address. So that gives you a little sense of where the exposure comes from in the mass arbitration front. So we'll now flip to the topic of what do you do if you get hit with one of these things? And the first observation in that regard is you're not going to know, for the most part, until the process is pretty far along. Our experience is not that employers see these things trickle in, arbitration demand on day one, another one on day two, another on day three. It's more like the phenomenon that Patrick described, where out of the blue, 1,000 of these land on the desk of the general counsel, where you already have enough of a critical mass to give the plaintiffs the leverage that we've been talking about so far. So let's go ahead to the next slide. There's really three things that an employer faced with a mass arbitration campaign can do. One is just decline to play. Take my ball and go home. I'm not playing with you guys. I'm not paying the fees. I'm not showing up at the arbitration. Years ago, that was actually a viable option. And Patrick and I worked on a pretty nasty mass arbitration campaign a few years ago, in the course of which the general counsel of a big company said to us, just make it stop. Mass arbitration is the worst thing that ever happened to me. I'll take my class actions back. I'll take PAGA, just anything but this, is kind of the response that you oftentimes get when you are hit with a mass arbitration campaign. And in some circumstances, it may still be an option for the employer to just walk away from its arbitration agreement. But the least impact that that's going to bring is an absolute nuking of your arbitration agreement. For the most part, historically, when companies have done that, the arbitration vendor, the AAA or JAMS, has said, we're just not going to arbitrate cases for you anymore, and we're going to close the existing files, and we're not going to accept any new ones for you. You're not an arbitrator anymore, which puts you back into a class action. That may well be better than a mass arbitration. But in light of some of these developments that Patrick highlighted, that option is not always available. And if any of these claimants are in California, there's a statute that is designed to make that option not available and to make arbitration agreements a one-way street. It's also foreseeable that other states could either enact similar legislation or reach a similar result judicially. We have looked at the question of whether a judge, for example, could compel a recalcitrant employer to pay arbitration fees if they get hit with a mass arbitration demand and they don't want to write that giant check. And the law on that is mixed. There's actually some case law that says a judge does not have the legal power to order an employer to pay arbitration fees, but there are cases that go the other way. And so if a given company's strategy in the face of the prospect of mass arbitration is just wait for it to happen, and if it does, walk away from arbitration and get sued in court, recognize that may not work. And you may be stuck in a really difficult situation if you make a move like that too late, which is to say after the arbitration portfolio has already hit you. Let's go to the next slide. So if we can't take the ball and go home, the next natural option for litigators is to fight them in the trenches. Go ahead and defend these cases. You brought me 1,000 arbitrations. Okay, I'm going to call your bluff, and I'm going to litigate 1,000 arbitrations against you into attrition. And there's a natural appeal to that from the defense lawyer's perspective. Oftentimes, these portfolios are brought by relatively small organizations, plaintiffs' lawyers running a shop of 6, 8, 10 people, where if they undertook to do what they're threatening to do, which is to simultaneously litigate 1,000 arbitrations, they would die under the weight of that. They simply could not do it. But as this phenomenon has continued to develop, we've seen the players in this space evolve with it. And the folks who are bringing mass arbitration portfolios forward at this point do not limit themselves to one small mom and pop shop full of plaintiffs lawyers. We've seen networks of these folks evolve where you might be dealing with multiple small to medium-sized plaintiffs firms. And we've even seen situations in which the most creative plaintiffs lawyers have affiliated with very large, what would typically be called defense side firms, to do these things on a contingency basis and really level the playing field in terms of the resources that they can bring to bear. And so in many cases, what seems like it's constructed as a bluff strategically, and it is, it's certainly intended to cause the employer to fold, they have the ammunition to back it up in a lot of cases. The second thing to think about is foreshadowed by what Noah said, which is the cost of these things are absolutely enormous. You don't recognize when you're stuck in court how great it is to be able to go into court for free and not have to pay the judge. But once you start defending one of these arbitration portfolios, that becomes salient. The fact that you're paying the judge increases the cost of these things by more than twofold, because you're always going to pay your own lawyers. And to get in the door, as Noah put it, you're going to pay $26.50 just to get the thing off the ground. But when we spec out the total cost of litigating an arbitration portfolio, you're probably looking at about $40,000 per arbitration paid in arbitration fees, plus what you're going to pay your own lawyers. meaning even if the merits are very strong for the employer and you're going to win, you're going to pay $100,000 a case or something in that neighborhood to win. And if you have to do that 1,000 times, that starts to smell a lot like a Pyrrhic victory. You're paying a lot of money out of pocket, and it's very likely you can settle the case for less than it would cost to spend what could be tens or even hundreds of millions of dollars to litigate an arbitration portfolio to conclusion. And a further observation that comes from having done this, defended arbitration portfolios, is the burden on the organization is not just financial. If you have 1,000 people bringing independent arbitration demands against you, you're going to have tremendous pressure on your organization to find documents pertaining to 1,000 people. You may have to find managers to testify at 1,000 different arbitration hearings. And so a huge portion of your business is going to be drained by responding to this portfolio, even if on the merits it's extremely weak. That option is also not ideal. Let's go to the next slide. The third option that we've talked about internally and with clients responding to these mass arbitration portfolios is fight back, attack the plaintiff's lawyers, and call the plaintiff's lawyers out for what they're doing here. There's a natural sense in which all of this feels extremely unfair from the employer's perspective because you've designed an agreement to avoid exactly what's happening, and you're getting exactly what you bargained not to have. And sometimes the conduct of the plaintiff's lawyers in rounding up these claims, particularly if you see what they're saying to the people whom they're soliciting, it oftentimes engenders outrage by the employer that a plaintiff's firm can do this. So one question we often get is, can we attack the plaintiff's lawyers for some of these things that they're doing? And many years ago, prior to the 1970s-ish, lawyers didn't advertise. It was considered unprofessional, unethical, all kinds of bad. But there's been a relaxing of that stigma over the years that continues to this point. And what plaintiff's lawyers can say within the bounds of the ethical rules is pretty wide at this point. So long as they're not saying anything that's overtly false, the ethical rules oftentimes give them more latitude than you might expect to recruit your employees to sue you and to go out there and engage in what looks like overt solicitation. You may have claims that you would pursue for defamation if they begin to step over the line and say bad things about your company that aren't true. You know, such and such retailer exploits its employees by doing this, that, and the other thing and imposing unreasonable demands. There might be all sorts of things that you can think of that you'd want to visit on the plaintiff's lawyers. But that kind of fails in two respects. First of all, as I've just suggested, you're not going to get much relief in courts. Judges generally are nonplussed by plaintiff's lawyers doing this, and you read some of the judicial opinions that this phenomenon has generated, and if anything, it feels like the judges are on the plaintiff's lawyer's side. Anytime an employer tries to avoid the obligations that a mass arbitration portfolio imposes, it oftentimes results in a really stinging judicial opinion about irony and the employer getting the results of its own labor and that sort of thing. But even where a remedy is available, it almost always comes too late. There are a multitude of things we could do. We could go into court and seek an injunction, which is not likely to happen. We could file a complaint with state bar authorities. And as mentioned, we could potentially file a tort claim against the plaintiff's lawyers. Even if you get traction with any of those things, it's going to come far too late, because you're going to begin that process only after you've been presented with a large portfolio of arbitration demands, and nothing that you're likely to get out of that process is going to undo the recruiting that the plaintiff's firm has already done. And so oftentimes when we tick through those options, while we do look at carefully the solicitations that the plaintiff's lawyers put out there, we find that there's no great angle to be pursued in striking back at the plaintiff's firm. So that leaves one option, which is our next slide, which is what happens when you've exhausted any useful way to defeat a mass arbitration portfolio and you conclude that you just have to swallow hard and pay to make this thing go away instead of incurring the wrath that we've talked about in terms of fees and organizational drain. And for the most part, the settlement of a mass arbitration portfolio looks a lot like the settlement of a class action. The real counterparty is just the plaintiff's lawyers. The individual plaintiffs have almost nothing to say about it. And it is somewhat extortionate in nature. That is amplified by the fact that it's generally not going to be subject to judicial review, unlike a class action. Now, there may be certain types of claims, for example, claims under the Fair Labor Standards Act, that may require somebody, a judge or maybe an arbitrator, to sign off on the deal in terms of its fairness. But for the most part, you don't have that check, which is both helpful and unhelpful. It means that the plaintiff's lawyers can extract more for themselves, but it also means that the ultimate deal is not subject to a great deal of scrutiny. It also creates some uniquely messy situations because in light of the fact that you don't have a court to oversee this dispute, we see all kinds of Wild West things going on as we try to wind down mass arbitration portfolios, which includes holdouts, individual arbitration claimants who just won't sign an agreement unless you give them lots and lots of money. So there are mechanisms that we sometimes apply to anticipate and deal with those things. And we even see claimants who have signed up to participate in multiple portfolios, signed up with 3 different lawyers who sent them ads, and you have to sort all of that out. And at the end of the process, one thing to be realistic about is that you don't have anything resembling a class release. The only piece you're going to get out of a mass arbitration settlement is the releases from the individuals that pertain to the period of time before they sign that release. And so it's not only conceivable, it's something we've seen happen, where a company will settle a mass arbitration portfolio and then have another one land on their desk, maybe even from the same group of plaintiffs' lawyers a few days later. So it may be that the point of my portion of this presentation was that the points that Patrick reviewed are really the key ones. Avoiding these mass arbitration portfolios is massively more important and easier to do than to avoid one once it's been visited upon you. So with that good news, I think it would be time to read the CLE code, which is SS, as in Seyfarth Shaw, 6372, SS 6372. And I believe, subject to any wrap-up that Noah has for us, that concludes what we intended to cover today.
Thanks, everybody. That will conclude our program for today.